I filed my eligible obligation.
What are you talking about? What are you talking about?
I'm talking about eligible obligation on the USCA.
Oh, you talking all that kind of stuff. I'm striking all that. If I hear it again, I'm not going to let you represent yourself. I promise you.
Oh,
That's enough. I don't want to hear another word.
okay. I'd like to also
Another one. I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. All right, Mr. Baker, you're before the court day for your arraignment. And let's see. Have you hired an attorney?
No, sir.
Do you plan on hiring one?
No, sir.
Are you going to represent yourself, or do you wish
Yes,
to have
sir.
the public defender to represent you?
No, sir. I'm representing myself.
All right, you're before the court today for your arraignment. You've been charged by way of an information with possession of a cocaine, possession of a controlled substance, count 1 and 2. Those are both third-degree felonies, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. You have a count 3, which is fleeing or attempting to elude high-speed reckless. I believe that should be a second-degree felony, punishable to 15 years in the Florida Department of Corrections and a $10,000 fine. Count 4 is drive my license, cancel, suspend, or revoke third or subsequent offense. That's a third-degree felony, punishable to 5 years in the Florida Department of Corrections and a $5,000 fine. And count 5, possession of marijuana less than 20 grams, which is a first-degree misdemeanor, punishable to 1 year in the county jail and a $1,000 fine. So you're looking at a total of about 30 years in the Florida Department of Corrections if you're convicted of everything and you get the maximum sentence. And you're still wishing to represent yourself?
Yes, sir.
Or if you'll raise your right hand to be sworn in.
Yes, sir.
All right, Mr. Baker, state your name.
Lee Baker.
And Mr. Baker, you have asked to represent yourself. Is that correct?
Yes.
How far did you get in school?
9th grade.
Okay. And so you can read and write?
Yes.
Okay. Are you employed?
No, sir.
All right. How do you make a living?
I'm unemployed right now. I was living with someone else.
Sir?
I'm unemployed. I was living with someone else. I just got out of jail about 5 months ago.
Okay. Well, what is your trade?
I have my own business,
All right. What kind of business?
a cleaning business.
Okay. And have you ever represented yourself before?
Yes.
All right. Let's see. Are you under the influence of any drugs or alcohol today, which would affect your ability to make this decision to represent yourself?
No.
Have you ever been diagnosed with a mental illness that would affect your ability to to make this decision?
No.
All right. You understand that attorneys are trained in the rules of evidence, criminal procedure, and the law, and they're there to assist you in preparing pretrial motions, preparing for pretrial hearings, and to participate in discovery, and also preparing for trial.
I comprehend that very well.
All right, and sir, you understand that if you're representing yourself, you'll be held to that same standard.
I comprehend that.
All right, and I cannot assist you in any way. The state attorney would not be able to assist you in any way. Is that correct?
I comprehend.
All right, you still wish to represent yourself?
Yes.
All right, Madam Clerk, if you'll print out the information, and Deputy Dexter, it's okay if the clerk hands the information to Mr. Baker? All right, Madam Clerk, if you'll do that. Mr. Baker, when you receive that information, I'm going to ask that you enter a plea at this time.
I'd like to file 2 motions on the record as well, sir.
I want to do your arraignment first.
All right.
All right, whenever you're ready, you'll let me know and you enter your plea.
I enter a plea of not guilty.
Okay. All right, you're filing motions?
Yes, sir. I
You have copies for the state?
Yes, I do.
Okay.
I got a declaratory judgment, and I want to furnish this bond to the clerk
You file it. Go ahead.
for my release from the Bay County Jail today.
Okay.
That's the declaratory judgment. That's for the clerk only.
Now you're providing a copy of the state, everything you've given the clerk?
The bond, I shouldn't have to give the bond. The bond goes straight to the clerk.
Anything you file that you want me to consider, you have to provide a copy to the state, sir. As you're representing yourself, you have to know those rules. If you don't, you're going to mess up.
I understand that.
If you're not providing to the state, I'm not going to consider it.
Okay.
And the clerk doesn't make any determinations on that. All the clerk determines is whether you're indigent or not.
I'm not talking about the bond for the declaratory judgment. I'm talking about the bond for the clerk to release me today. I filed my eligible obligation.
What are you talking about?
Sir,
What are you talking about?
I'm talking about eligible obligation on the USDA.
Oh, you talking all that kind of stuff. I'm striking all that. And, if I hear it again, I'm not gonna let you represent yourself. I promise you. He's already entered a not guilty plea. We'll set this for a pre-trial. We'll set it for don't ask me any questions like that, sir. I'm not answering any questions. If you want to file a motion, file your motion. We'll set it for our December, when's that motion day in December? December 19th at 9:00. Sir, you may, if you're going to do the sovereign citizen and all that, you may want to consider having the attorney.
I'm a private citizen, sir. I'm not a sovereign citizen. I'm a private citizen.
Listen to me. If you're going to pursue that, you may want to reconsider representing yourself.
No, sir.
But I'm not going to pay attention to any of that, and I'm going to strike all that.
Okay.
So we'll see you December 19th at 9:00.
It's no problem.
That's enough. I don't want to hear another word.
Okay, I'd like to also.
I don't want to hear another word. No, put him out.
Put your hands on me like that.
Hush. Get him out of the courtroom. I don't want to hear another word. I just heard another word, Mr. Baker. Hush. Whoa. Mr. Baker, I'm going to appoint the Office of Public Defender to represent you. I'm going to find that you're not competent to represent yourself at this time. I'm going to reverse my decision. The Office of Public Defender is going to represent him. We'll keep it on that December 19th date. I just did. Come on now. Y'all close that door where I can't hear him or he gets in any more trouble.
This courtroom hearing centers on Lee Baker, who was facing multiple criminal charges in Florida, including 2 counts of possession of a controlled substance, fleeing or attempting to elude at high speed, driving with a canceled, suspended, or revoked license, and possession of marijuana. The judge explained that, if convicted and given maximum sentences, Baker could potentially face decades in prison. At the arraignment, Baker chose to represent himself despite having only a 9th grade education and no current employment. The judge carefully questioned him about his ability to read and write, his mental state, possible substance use, and his understanding of the risks of self-representation. Baker repeatedly confirmed that he understood the responsibilities and still wanted to proceed without an attorney. Baker entered a plea of not guilty and attempted to file several documents, including what he described as a declaratory judgment and an eligible obligation connected to federal law. The judge warned him that any motion he wanted considered had to follow proper court procedures and be provided to the prosecution. The situation quickly deteriorated when Baker began making arguments involving his status as a private citizen and concepts associated with sovereign citizen ideology. The judge made it clear that those arguments would not be entertained and repeatedly instructed Baker to stop. When Baker continued speaking after being ordered to remain silent, the judge had him removed from the courtroom. The judge then reversed the earlier decision allowing Baker to represent himself, finding that he was not competent to proceed pro se at that time. The Office of the Public Defender was appointed to represent him, with the case remaining scheduled for a future hearing. This case shows how quickly courtroom proceedings can unravel when a defendant refuses to follow procedural rules or disregards direct instructions from the bench. What do you think about the judge's decision? Like this video, subscribe to the channel and comment your thoughts below.